One wrong word to police after a self-defense shooting, and you're facing felony charges, even if the shooting was 100% justified. I've researched countless cases of law-abiding gun owners who destroyed their own self-defense cases in the first 5 minutes after pulling the trigger. Today, I'm breaking down 7 deadly mistakes that could get you arrested, sued, or imprisoned after a defensive shooting. By the end of this video, you'll know exactly what to say, what not to say, and how to protect yourself legally when you've just protected yourself physically. This is happening right now. Legal experts who handle self-defense gun cases report seeing the same fatal errors repeated over and over. The worst part? These people thought they were doing everything right. Number 1. Thinking your attorney can storm the police station like you see on TV. Here's the brutal truth that Hollywood won't tell you. We've all seen that police show. You're in the dark interrogation room, sweaty cop leaning over the table, tie dangling, shirt sleeves rolled up, that single light hanging down. You're exhausted, terrified. Your blood sugar has crashed because you didn't plan the worst night of your life. The bad guy did when he broke into your house or tried to rob you on the street. Then what happens? Some attorney in a gray suit with a brown leather briefcase strolls through the police department at 2 a.m., waves hi to the cops, busts into that interrogation room, makes some witty remark, tells the detectives to scram, turns off the recording device, and boom, the cavalry has arrived. You're saved. Here's the problem. That makes great fiction and great drama, but it does not make great fact because it does not happen that way. In every state, if a defense attorney tries to do that, they are getting tossed and arrested in that lobby. They will be your cellmate, not your attorney. Under the Fifth Amendment and criminal procedure rules, the only person who can save yourself is you. You already did it once when you survived the kinetic encounter. Now you need to do it again with the legal force encounter. And rest assured, the law is force, the law is violence. If you don't believe me, don't do what the cops say and see what happens when men with guns and badges show up. Here's what you must do instead. The moment police want to question you, you must clearly and directly invoke your right to an attorney yourself. Say these exact words: "I will not answer any questions until I've spoken with my attorney." Your attorney cannot raise your rights for you. They cannot fax or transmit some sort of notice. They can't shout it from the parking lot. Just like with carrying a gun, the only person who can save you is you. This brings us to the second deadly mistake, and it's about knowing which right to invoke. Number 2, raising your right to remain silent when you should be invoking your right to an attorney. You need to understand that there's a difference between raising your right to silence and raising your right to an attorney. One of these is much better than the other. Do you know which? If you said your right to an attorney, you are correct. Here's why this matters legally. If you raise your right to silence, police can basically keep harassing and badgering you. They can come back every 20 minutes, try different approaches, wear you down. But by sharp contrast, if you raise your right to an attorney, they should back off immediately. That's the law. The best thing you can do is politely and respectfully be firm and steadfast when you tell law enforcement clearly, "I'm not going to answer any questions until I've spoken with my attorney." Now here's something critical. If they are good cops and if they believe you acted truly in self-defense, they should be screaming to themselves in their internal monologue, stop talking, as they're writing everything down. They will do their job to get you to talk. That is literally their job. Don't fault them for that. But think about this. If cops are involved in an OIS, an officer-involved shooting, do you think they're going to talk to police and give a full statement right away? No. They're going to be given 2-3 days, maybe even longer, and a chance to speak with their attorney to figure it all out. They're going to level out their sleep, level out their blood sugar, medication, whatever it is. They're going to have a chance to put all the pieces of their mental puzzle together before they give the statement of a lifetime that may be the difference between a lifetime behind bars or going free to their family. You deserve nothing less. Make no mistake about that. But here's where it gets tricky. There's one more thing you need to know about invoking rights. Number 3, raising your rights and then opening your mouth anyway. Here's what you've got to understand. Just because you've raised your rights once doesn't mean that if you suddenly start getting chatty and making statements, that won't constitute a waiver at worst or some sort of spontaneous utterance at a minimum. That's all code for this. You can't just raise your right and then start talking and think, "Oh, that's good because I raised my right back there." No, if you start talking, you initiate that conversation again, particularly if you raised your right to an attorney. Legal experts report seeing this destroy cases. Someone says, "I want my lawyer," then 5 minutes later they're nervous, the silence is uncomfortable, and they start explaining what happened. Boom! Everything they say comes in against them at trial. If you invoke your right to an attorney, you must stay silent. Don't make small talk. Don't try to explain yourself. Don't think you're helping your case. Every single word you say after invoking can and will be used against you. Law enforcement will write down everything. They'll note your tone, your body language, your word choices, and prosecutors will pick apart every inconsistency in court. That spontaneous utterance you made, it's now Exhibit A in your trial. Here's the rule. Invoke clearly, then shut up completely. Not another word until your attorney is physically present with you. Now let's talk about the biggest mistake people make right at the scene. Number 4, trying to give a detailed statement when you're in the worst condition of your life. You've just been in the most traumatic event of your entire life. You're exhausted, your adrenaline is spiking and crashing, your blood sugar levels are out of whack, you're in shock. And right then and there, in the chaos of the scene, is not the time to be trying to pin yourself down to exact details. Research and case studies show that good people make very basic mistakes in this exact situation because of the stress, the anxiety, the excitement, the sleep exhaustion, the low blood sugar levels, you name it. Legal professionals who handle self-defense cases report seeing people get the wrong day, the wrong time, the wrong street, wrong basic facts, not because they're trying to mislead, but because they've just been through hell. Here's what happens when you guess at the scene. You say, I shot 3 times, but it was actually 4. You say he was wearing a white shirt, but it turns out it's silver. It's nighttime, an understandable mistake. But you've now married yourself to a fact that's wrong. This leads to police questioning. Well, he got that wrong. Did he do that because it was an honest mistake, or is he lying to us? Is he misleading? Is he hiding or covering something up? Those are the sorts of inquiries that you get when you try to give too much information. So what should you say at the scene? Here's the recommendation from legal experts. If you had to shoot, say this: Officer, I had to shoot. I was attacked. I was in fear for my life. I will make a statement after speaking with my attorney. If they have an unconventional weapon, like a screwdriver, and they broke into your garage, or a baseball bat, or a 9-iron, law enforcement may not automatically see that as a weapon, particularly if you have a messy house. Point that out to them. He was charging me with this. He had that. Don't make your lawyer's job harder by letting critical evidence go unnoted. But beyond that, stop talking. Don't guess at how many rounds you fired. Don't estimate distances. Don't try to reconstruct the timeline. You will get details wrong, and those wrong details will haunt you in court. Here's the next mistake, and it involves people you trust most. Number 5, forgetting that everyone in your life becomes a witness to your case. Everybody who's in your bubble, your spouse, your best friend, the people you go out with. Defense attorneys have a name for them. You know what that is. Starts with a W, witness. That person will be a witness to your case. You're watching this content, and you've made it this far in this video. Congratulations, you're on the right track. But are they watching this video? Do they have this knowledge? Unfortunately, legal experts report seeing many cases where the concealed carrier made all the right decisions. They've been through all the right training. They raised their rights at the scene, all that good stuff, only to have a friend, a spouse, maybe an older child just start talking. Not a good idea. Everybody in your bubble who you go places with, do things with, live with, those people can also be a witness to your case. And law enforcement will lean on them to give statements. They need to understand how to protect your rights. Here's what happens. Police can't question you because you invoked your rights. So they turn to your wife in the next room. They tell her, we just want to understand what happened. He's not in trouble. We're just gathering facts. She wants to help you, so she talks. She mentions you've been stressed about money lately. She mentions you've been carrying your gun more often. She mentions an argument you had last week. None of that is illegal, but now the prosecutor uses it to paint you as someone who was looking for a confrontation. Your own spouse just handed them a motive narrative, and she had no idea she was hurting you. Exactly as if this was an officer-involved shooting, everyone in your circle needs to understand. I will make a statement after consulting with an attorney. Train them now, before anything happens. This next mistake happens when people think they're being helpful. Number 6, volunteering to be the world's best witness when you should be protecting yourself. Here's the most statistically likely situation. You are a witness. You produce a firearm when someone threatens you with grave injury and violence, and the bad guy runs away. Statistics show this happens about 91% of the time when a good guy displays a gun, the bad guys run away. That's a good thing. We don't want to hurt people. That's not why we carry. We don't carry to take life. We carry to save and protect it. In that situation, it's reasonable to acknowledge the facts and try to be a good witness. Try to give a description. He looked like this. There were this many of them. They were dressed like that. They were this height, this body build, skin color, you name it. They got into a truck, car, then that looked like that. They went in this direction. Try to be a good witness. A plus on that. But try not to go into many details beyond that. Even that can be a risk. Here's why. What happens if you describe it as a white van, but it turns out to be silver? It's nighttime. It's an understandable mistake. But you've now married yourself to it was a white van. Legal case studies show this can lead to police questioning. Well, he got that wrong. Did he do that because it was just an honest mistake? Or is he lying to us? Skip the guesswork about how many times you shot. It's going to be very evident and obvious that you shot. But skip the guess, and experts emphasize it as a guess about whether it was 3 times or 4 times, whether you were at this angle or that angle, all those specific tactical details. Be a good witness for suspect identification and direction of travel. But don't try to reconstruct every detail of your own actions when your memory is unreliable. Now here's the final and perhaps most dangerous mistake of all. Number 7. Assuming the truth will automatically come out because you were justified. You're in the second situation where you had to shoot and you've got a body on the ground, whether they're dead or in the hospital. That person or their friends, more likely, because bad guys move in packs, are very likely to say something to the effect of, you tried to do something bad against them. They were trying to flee, or they were trying to act in self-defense. How do we know? Because defense attorneys report that's what happens in 90% of self-defense cases they handle. The bad guys claim they're just the victim, at least according to them. If you are lucky, one of them will roll on another one. If you are lucky, there's audio-video recording of the entire thing showing who initiated and said what. If you are lucky, there are outside witnesses. But then again, if you were lucky, you probably wouldn't have been at that place at that time when this happened. So let's not owe it all to luck. Here's the reality. The person who attacked you or their associates will lie. They will claim you were the aggressor. They will say they were retreating. They will say they never had a weapon. They will say you used racial slurs or threatened them first. Anything to flip the script and make you the bad guy. And here's the kicker. If you've already given a detailed statement at the scene when you were traumatized and got facts wrong, the prosecutor now has ammunition. The defendant claims he feared for his life, but he can't even remember basic details correctly. What else is he lying about? Meanwhile, the bad guy has had time to coordinate his story with his buddies. They've had time to get their lies straight. And because you talked first without counsel, you've locked yourself into a version of events that you can't change, even if you later remember it differently. This is why you protect yourself first by invoking your right to an attorney. Let your lawyer help you give an accurate, complete statement after you've had time to stabilize, review any evidence, and understand what the other side is claiming. Don't gamble your freedom on the assumption that truth automatically wins. In court, the side with the best preparation and legal strategy wins. Let's recap the 7 deadly mistakes that could land you in prison after a justified shooting. Believing your lawyer can bust into the police station and save you. Only you can invoke your rights. Invoking your right to silence instead of your right to an attorney. One is far more protective. Raising your rights and then starting to talk anyway. You waive your protection the moment you speak. Giving too many details at the scene when you're traumatized, you will get facts wrong. Letting family and friends talk to police without preparation. They become witnesses against you. Trying to be a perfect witness with perfect recall. Your memory is unreliable after trauma. Believing the truth will automatically come out. The bad guys will lie, and you need legal protection. Any one of these mistakes could cost you tens of thousands in legal fees, years behind bars, or your right to own firearms forever. Don't let confusion about self-defense rights put you at risk. Subscribe to Guns Law Guide so you never miss an update that could keep you legal and protected. I break down complex gun laws every week so you can carry with confidence and know exactly what to do if the unthinkable happens. Next video, I'm covering the 5 places you think you can carry concealed but will actually get you arrested, including one location that surprises 90% of gun owners. You won't want to miss it. Remember, just like with carrying a gun, the only person who can save you is you. Know your rights, invoke them clearly, and protect yourself twice, once in the fight and once in the legal battle that follows.